Relocation. Active duty personnel are subject to permanent change of station orders, i.e. PCS. Therefore, active duty personnel need to be aware of the factors a family court considers in custody and visitation when one parent relocates. When one parent relocates, family court needs to come up with a child sharing arrangement between the parents. The family court will take into account the best interests of the child, also known by its acronym BIC. Most states use the same best interests of the child factors. In California, these factors have been specifically enumerated in the 2004 California case called LaMusha. The 2004 California LaMusha case enumerates 8 best interests of the child relocation factors. First, stability and continuity. 2, distance. 3, ages of the children. 4, the children's relationship with the parents. 5, relationship between the parents. 6, children's preference and maturity. 7, reason for the move. 8, timeshare and opportunity to see the children. If the service member is the non-custodial parent and is moving to a new permanent duty station, or PCSing, the service member should see if the child can spend the following periods of time with the service member. 1, the entire summer minus a week at the beginning and the end. 2, alternating Christmas holidays. 3, entire spring break. And 4, visitation when the service member is in town with notice to the other parent. Factors a service member should consider in developing a long-distance child sharing plan. First, are the children in a traditional or year-round school? 2, the ages of the children. Can the children travel unaccompanied? 3, what is the cost of transportation? And 4, what support systems are available at the permanent duty station, such as daycare options and summer activities depending on the ages of the children. California Family Code Section 3047. A party's absence, relocation, or failure to comply with custody and visitation orders shall not by itself be sufficient to justify a modification of a custody or visitation order if the reason for the absence, relocation, or failure to comply is the party's activation to military duty or temporary duty, mobilization in support of combat or other military operations, or military deployment out of state. If the service member is deploying or underway, a temporary custody order can be entered to accommodate the service member's absence. The service member can request that the custody and visitation order that was in place prior to the deployment be reinstated after a return from deployment. There shall be the presumption that the old custody arrangement should be reinstituted unless there is a determination that it is not in the best interest of the child. The temporary custody order shall consider measures to ensure the deployed service member can maintain frequent and continuing contact with the child by means that are reasonably available. The service member can request that the court grant reasonable visitation to a step-parent, grandparent, or other family members if the court finds all the following. First, a pre-existing relationship and bond so that the visitation is in the best interest of the child. 2, the visitation facilitates the child's contact with the deployed service member, such as Skyping the service member while with a step-parent. And 3, balance the interests of the child in having visitation with the service member's family members against the non-deploying parent's right to exercise parental authority. Tip: use Family Code 3047 to accomplish the following. Join family members, such as grandparents or new spouse, in the family law case on the grounds that they need to be joined to make their visitation orders enforceable. However, beware that a joinder may expose the joined party to paying attorney's fees. A joined party may be subject to paying attorney's fees and costs but only to the extent that those fees and costs were reasonably incurred to maintain or defend the joined party on issues related to the controversy involving that party. The takeaways. Service members have unique child custody and visitation issues. Service members are at a distinct disadvantage in family court because of the intense demand of their careers. Service members have to be more proactive in asserting themselves in their children's lives after separation. Immediately shore up parental fitness issues such as anger and PTSD. The military has a multitude of programs to assist the service members and their families. Research what your post offers you. If the service member is PCSing, analyze your options using the LaMusha factors. Use California Family Code Section 3047 to set up a visitation schedule with the service member's family before deploying.